When the Constitution was written, it was contemplated that some day may come when an unscrupulous person wins election to office, someone who disregards the rule of law and uses his office not for the good of the people, but for his own personal enrichment. As a remedy, the process of impeachment was written into the Constitution. Impeachment provided for the orderly transfer of power from the president to the vice president. The Constitution also provided for the transition of power in cases of presidential incapacity. That is, the power goes from the president to the vice president, and if necessary, from the vice president to the Speaker of the House. But the original version of the Constitution did not consider that a cancer could develop within the government, that due to that cancer, people within the government, people of authority, could ignore the rule of law and cause someone to illegitimately assume the office of president. When that possibility became abundantly clear, the Constitution was amended to provide for the removal from government all those, including a president, who embody that cancer. The clearest indication that a cancer exists is when an attempted insurrection occurs, when people are killed and death threats are shouted. Section 3 of the 14th Amendment calls not for the impeachment of a public officials, but for the cutting away of the cancerous cells. Legislators have the power of impeachment. The judicial branch has the power of removal, granted by the 14th Amendment, to purge the government of those who participate in, give aid to, or comfort an insurrection. Judges are supposed to sit quietly and wait until someone, a prosecutor, an injured person, or a wronged citizen runs to his courtroom waving some statute and demanding he protect the rule of law. That is a simplified but accurate description of a judge. When the plaintiff, the person waving the statute, proves to the judge that a rule of law has been violated, that something which ought to have been done has not been done, it is the judge's duty to enforce the law and fashion a remedy to restore justice. There is no federal district court judge who could honestly find that an insurrection did not take place after reviewing the Colorado Supreme Court decision, reading the Jack Smith report, and listening to the testimony of millions of people who witnessed the mob action of January the 6th. The only issue to be decided is who, within the government, participated in the insurrection, and who gave aid and comfort to the insurrectionists. The mandate of the 14th Amendment is clear. Find those government officials who are associated with the insurrectionists and declare their authority ended the moment they sided with the insurrection. As I stated earlier, impeachment is a creature that resides in the legislative house. Legislators can vote however they please, but their actions have consequences in the judicial house. Voting to give aid and comfort to Trump, voting not to impeach him, is an act that, within the clear meaning of the law, destroys their right to further participate in our government. When justices of the Supreme Court side with insurrectionists, they too lose their positions. Supreme Court justices are not above the law. If one commits a crime, he must answer for it. If one commits a civil offense, he is subject to the decision of a lower court and cannot use his position to circumvent that decision. The 14th Amendment does not create any criminal liability. The rules of criminal law, do not apply when the enforcement of that amendment is sought. For instance, it need not be proven that a justice or a senator aided an insurrectionist beyond a reasonable doubt. It is only necessary to show, as in any civil case, that more likely than not, he provided such aid. When you as a citizen go to your local federal court seeking the removal of the president, the Supreme Court justices, senators, and congressmen, you have to realize the enormity of your demand. Every one of our 600 district court judges will initially doubt their power to do what you ask. Each will take a deep breath and then, hopefully, do their job. It is for you to tell them to take baby steps. First, find that an insurrection occurred. Then examine the evidence you present that show aid or comfort was given to the insurrectionist. If such evidence proves that more likely than not such aid was given, tell the judge he is duty-bound to excise that government official and void all actions of that official committed after and in pursuit of the insurrection. It is the judge's duty to fashion a remedy when a violation of the law has occurred. Millions of legitimate votes were cast for Kamala Harris, and not one valid vote was given for Trump. In Venezuela, Nicolas Maduro refuses to give up his presidency in spite of overwhelming evidence his opponent won the election. Tell the judge we have a duty to the world to show how a democracy cherishes the rule of law. Tell the judge he must declare Trump illegitimate and Kamala Harris the legitimate president of the United States. Tell the judge to issue a preliminary injunction suspending Trump's power so that we can avoid irreparable damage to the country. Ask him to appoint a conservator in his place until the case is finished. If this happens, the issue will quickly go to the doorstep of the Supreme Court, and Trump could be out of office within weeks. Since 1945, there have been at least 83 times non-lawyers have argued before the United States Supreme Court. Over half that number have won. This plan of action depends upon non-lawyer and lawyers to bring multiple cases and to eloquently express their arguments. Don't say this is preposterous. Don't say it can't be done. There are plenty of honest, conscientious judges who fit the mode of profiles of courage, and there are plenty of such citizens too.